Hello everybody. Welcome back to my YouTube channel. My name is Rishabh and this is our revision lecture number 5 of entire MCQ oriented fast track batch of CA Final SPOM Corporate and Economic Laws. In this series, we are going to cover the most important chapters of your CA Final SPOM that can easily fetch you more than 60 marks. This is our revision lecture number 5, and in this lecture, we are going to cover Insolvency and Bankruptcy Code 2016. Now, without wasting much of time, let us begin. Before starting this video, let me tell you, this entire PDF you can get in the Telegram channel, the link of which is given into the description. Please do check out that channel and you will be able to access this document there. Apart from this, if you like this video, please share it with your all the friends so that whoever is facing any kind of issue with respect of SPOM Set A law, they can watch these lectures, they can use these notes and will be able to clear their examination in the very first attempt. Now let us start with the IBC. Now, IBC stands for Insolvency and Bankruptcy Code 2016. So what does insolvency means? Insolvency means when a situation when your liabilities are more than your assets and you are unable to repay your liabilities. Such a situation is called as insolvency. When IBC was introduced, IBC was established in October 1, 2016. Applicability of IBC code. To whom IBC is applicable? IBC is not applicable to the individuals. Okay, IBC is only applicable to the corporates, companies, as per the Companies Act 2013. Companies which are governed by special laws, limited liability partnerships, any body corporate which is notified by central government, personal guarantor of the corporate debtor. The definition of corporate debtor we will learn in the subsequent part. Individuals other than persons referred in the last point. Now, point number 4 talks about IBC is whom IBC is not applicable. IBC is not applicable to the entities which are in the financial service sector, such as your banks, financial institutions, insurance companies, asset reconstruction companies, mutual funds, collective investment scheme companies, and pension fund companies. These are the list of the financial service providers under your IBC to whom IBC is not applicable. Apart from this, non-banking financial company, if their asset size is less than 500 crores, then in such a case, IBC is not applicable to them also. But if asset size is more than or equal to 500 crore, even if asset size is exactly 500 crore, then IBC would be applicable in case of NBFC. This has been, declared by IBC board through a notification. Now moving on to the important definitions. There are a lot of important definitions that is given into the module, but I have picked only the most important ones that are relevant for your examination. If you want to detail or have a thorough understanding of this entire chapter, then I would recommend you to please go through the entire, your module, ICI module, and you will be able to have a great understanding of the entire chapter. This PDF only concludes the summary part, the most important parts of the chapters from which MCQs can be framed. Now, who is a corporate debtor? Means a corporate person who owns a debt to any person. Let's say I am a XYZ company. I have borrowed money from let's say any of my creditors, any of the operational creditors like employees I have to pay. So I am a corporate debtor. I am a corporate debtor. XYZ is a corporate debtor. Now, who is a creditor? Creditor means a person from whom I have borrowed some money or from whom I have taken some services but I have not made any payment to them. Now, who and all are included in the definition of creditor? Financial creditor. Who is a financial creditor? Means a debt instrument holder. I have issued debt instrument to a lot of people. So all those people are financial creditor to me because they have provided finance to me to run my company. Operational creditors. Who are the operational creditors? Such as your sundry creditors. You purchase raw material from some of the suppliers. Sorry. Those are your operational creditors. Apart from that, employees. Your employees, whoever are there, let's say any outstanding to the employees, those are also what? Those are also your operational creditors. Secured creditors, let's say you borrowed some money from a bank. In such a case, you pledged some of your securities, some of your assets. Then those banks are also caught under your definition of creditor. Unsecured creditors means you borrowed money from the bank without pledging or mortgaging any kind of security. And the last one is decree holder. Corporate applicant. What is the meaning of corporate applicant? Means who can file an application to the NCLT adjudicating authority for issuance for starting of CIRP, corporate insolvency and resolution process. This entire thing we are going to study in the subsequent part of this chapter. Now, who is a corporate applicant? Means who can make application to the tribunal, who can make application to the NCLT adjudicating authority saying that please initiate the CIRP process. CIRP stands for Corporate Insolvency and Resolution Process. The corporate debtor can make an application. Member partner of corporate debtor who is authorized by the CIRP, authorized to make CIRP application. Let's say a group of promoters have authorized a particular person to initiate CIRP proceedings, and who has been authorized to make application for CIRP. Individual who is in charge of managing the operations and resources of the corporate debtor. A person apart from the board who is in charge, who is responsible for managing the affairs of the company, can also make application. Is also considered as a corporate applicant. Person who has control and supervision over the financial affairs of the corporate debtor, that is also covered under the definition of corporate applicant. Now, point number D talks about CIRP initiation date. So when does CIRP starts? The date, what is the date of initiation? So there are two dates. One is commencement date and one is initiation date. So when an application for CIRP is made, that date is considered as CIRP initiation date. Date of making application to the adjudicating authority is considered as a date of initiation. What is insolvency commencement date? The date when the adjudicating authority accepted that application from the corporate applicant. That date is considered as what? That date is considered as insolvency commencement date. So please be very careful with these kind of differentiation, because these MCQs can be from these kind of questions. Apart from this, let me tell you, this corporate debtor we understood, no? In my examination, there was a question, entire case study was given. I was asked to find out who is a corporate debtor, who is a creditor, that means a financial creditor, and who is a corporate applicant. All the three I had to answer in that particular case study. So please be very careful with these definitions also. CIRP initiation date, CIRP commencement date, I hope you are clear. Corporate insolvency resolution process. Now we have heard what corporate insolvency resolution process, but what is it exactly? Once a company has become insolvent, once a company is unable to pay its dues, when its assets are less than its liabilities, then in such a case company will become a insolvent company. Now, corporate insolvency resolution process, what is this? When we are going to file an application to the NCLT adjudicating authority saying that I owe some money to this particular corporate person, then CIRP initiation, corporate insolvency and resolution process comes into the picture. There should be a default in payment. There is a default in payment by the corporate debtor. That means the company has made a default in the payment of the repayment of the finances, or in the repayment of the raw material which the company has got from the secured creditors or from unsecured creditors also. Application to the adjudicating authority by the financial creditor, operational creditor, or corporate applicant. So all the three we have learned over here. Any of them can make an application to the adjudicating authority for initiation of CIRP, corporate insolvency and resolution process. Now, adjudicating authority shall accept or reject the application within 14 days. Again, a very most important timeline. I have spoken to 5-6 of my friends. Most of them were talking about that a question has been asked from this timeline. What is the time limit for acceptance or rejection of the application from the corporate applicant by the adjudicating authority? So the adjudicating authority shall within 14 days accept or reject the application. Once you have made the application, adjudicating authority will respond to that particular application. Either it may accept or it may reject within 14 days. If application is accepted by the adjudicating authority, then what will happen? Then adjudicating authority will appoint IRP, insolvency resolution professional, a person who will take in charge of the entire proceedings until the resolution professional is appointed. Now, who is IRP? So that we will understand in the later part. But in insolvency resolution process is the insolvency resolution IRP, insolvency resolution professional, is a person who is appointed by the adjudicating authority, who will take care of the entire company until the RP is appointed. Now IRP will issue notice to the public notice. The timeline we will study in the later part. So after appointment, after acceptance of application by the adjudicating authority will appoint IRP. IRP will issue a public notice saying that whoever is having any kind of money outstanding from the company, please file your claims with the company. Moratorium period, it is a calm period wherein no transactions are going to undertaken. In the detailed study of this we will going to discuss in the later part, and CIRP will start. Now, apart from this, formation of committee of creditors to be held within 30 days of acceptance of application. Once within 14 days the adjudicating authority will accept the application. From that day, 30 days, next 30 days, committee of creditors is to be formed. What is this? This is also we are going to study in the later part. Now IRP shall within 7 days from the date of constitution of the committee of creditors shall conduct the first meeting of COC, committee of creditors. So 30 days mein COC will be formed, and then within the next 7 days within the next 7 days of the constitution of committee of creditors, what will happen? The committee of creditors ka first meeting will happen. Again, very important timelines from the exam perspective. In the meeting of COC, there shall be appointment of IRP as the RP means resolution professional, formation of memorandum, and or liquidation. Any of these things can happen. Now, RP plus COC shall finalize resolution plans and submit it to the NCLT, National Company Law Tribunal. So what we saw, all these 8 points, this is the entire process of CIRP. How does the CIRP process work? So first one is there will be a default in payment. Application will be filed to the adjudicating authority. Adjudicating authority will accept the application. Upon acceptance of the application, adjudicating authority will appoint whom? Will appoint IRP, insolvency resolution professional, who will take care of the company until resolution professional is appointed. Moratorium period will start from the date of acceptance of the application. CIRP will start. CIRP commencement date will come into effect, and IRP will issue a public notice to the general public saying that whatever claims you have, please file it with me. Upon appointment of IRP shall constitute formation of committee of creditors is to be conducted within next 30 days. Upon constitution of the committee of creditors, the first meeting of the board of directors of the committee of creditors, is to be conducted within next 7 days. In the meeting, there will be appointment of IRP as IRP as RP. There will be formation of memorandum, or liquidation can also take place. RP plus committee of creditors shall finalize the resolution plan and submit it to the National Companies Law Tribunal. This is what the entire process of CIRP looks like. Now, application for CIRP only if default is more than 1 crore. Here we studied that who is a corporate applicant who can make application for the CIRP, but under what circumstances who can make application. Now, application for CIRP can be made by financial creditor, operational creditor, or corporate debtor also. Corporate debtor means the company itself can make an application to the NCLT adjudicating authority saying that please initiate the CIRP, corporate insolvency and resolution process. Now, only if default is more than 1 crore, in such a case, application is to be filed. Financial creditors, there is a default in payment by corporate debtor to the financial creditor. Financial creditor shall make an application to the NCLT. They will directly make an application to the NCLT. Now, here operational creditor, this is an important point. There is a default in payment by the debtor to the operational creditor. In such a case, operational creditor, जो भी होगा, he will send a demand notice along with the copy of the invoice. He will send to the corporate debtor. Now, corporate debtor shall within 10 days shall respond with either existence of dispute if any or evidence of repayment. There is a default in payment. Corporate debtor ko operational creditor will send a demand notice along with the original copy of invoice. Now, within 10 days, the corporate debtor has to respond to that particular notice. He may either accept or reject the claim or may reject the claim. If he rejects the claim, then he has to also mention what is the existence of dispute, whether there is an existence of dispute, or if he has made the payment, then evidence of payment he has to furnish to the operational creditor. Now, OC shall make application to the NCLT. Now, once he has received the response from the corporate debtor, operational creditor will make application to the NCLT saying that we are willing to initiate CIRP procedure. Corporate debtor may himself can file an application for CIRP if he feels like he is unable to run his company with the available finance. Now, one more important thing, adjudicating authority. So the adjudicating authority, wherever we are going to discuss in this chapter, it would be NCLT, National Companies Law Tribunal, and adjudicating authority shall within 14 days accept or reject the application. This we have already studied. Now, person who is not entitled to make CIRP application. We studied who is entitled to make CIRP application. Now we are going to study who are those persons who are not entitled to make CIRP application. A corporate debtor himself cannot file an CIRP application if he is undergoing with CIRP. Financial creditor, operational creditor undergoing PPIRP. PPIRP is pre-packaged insolvency resolution process. So financial creditor or operational creditor, whoever is undergoing with PPIRP, they cannot make an application for CIRP. Corporate debtor having completed CIRP within 12 months before the date of making the application. Corporate debtor has completed with the CIRP process within the previous 12 months before making as on the date of making application. In such a case, that corporate debtor cannot make application for CIRP. Corporate debtor in respect of a resolution plan is approved in the preceding 12 months. Resolution plan we are going to study in the later part of the chapter, but if a corporate debtor against whom a resolution plan has been approved in the preceding 12 months, then in such a case that corporate debtor cannot make application for CIRP. Corporate debtor or financial creditors has violated any of the terms of the resolution plans in the previous 12 months. Here we studied there was a plan approved for resolution. Here we are studying that there was a plan approved, but the corporate debtor has violated the provisions of that resolution plan. In such a case, the corporate debtor cannot make application for CIRP. Corporate debtor in respect of whom a liquidation order has been made. A corporate debtor in respect of whom if a liquidation order is made, in such a case that person cannot make application for CIRP. What is the CIRP completion timeline? Once you have initiated the proceedings, CIRP is to be completed within maximum of 180 days. But there can be extension of this 180 days by another 90 days. So there can be an extension of 90 days can be granted if resolution is passed at the COC meeting by 66% of the total voting shares. मतलब total 66% of voting shares ने अगर वहाँ पे voting कर दिया कि we are willing to extend the timeline to complete CIRP, then in such a case the extension can be granted maximum of 90 days. The third point is, in case of litigation, the above time shall not exceed maximum of 330 days. So maximum if there is no dispute, then CIRP is to be completed within 180 days plus 90 days of time limit extra can be granted. But if there is an existence of a dispute, then maximum of 330 days के अंदर आपको CIRP has to completed. Now point number 11 talks about declaration of moratorium period. So what is a moratorium period? It is a calm period of 120 days during which all the suits and legal proceedings are kept in abeyance. All kind of transactions that are going to undertake into the company are kept in abeyance. All the suits and legal proceedings are kept in abeyance. Now 12th point talks about public announcement. It is to be made by the IRP within maximum of 3 days of appointment as IRP with respect to submission of claims. Now here we had studied in the last year, we had studied that, where is it? One second. Here we had studied that, just a second, where did it go? Yeah, IRP will issue public notice. Here we studied IRP will issue public notice. Now here we are going to see by what is the maximum time limit up to which the public announcement is to be made. Public announcement is to be made within maximum of 3 days from the date of appointment of any person as IRP. If you are appointed as IRP, then public announcement you have to make within the next 3 days. This is the maximum time limit, and this question was asked in my examination. Point number 13 talks about section 16 to 20, appointment of IRP and its power. IRP can be proposed by financial creditor or operational creditor. We studied that FC or OC can make application for CIRP to the adjudicating authority. While making an application, they themselves can propose any person to be appointed as IRP. But in case they failed to propose any person as IRP, then in such a case, the adjudicating authority will refer the case to IBBI. IBBI then will appoint within 10 days a IRP, insolvency resolution professional. So the time limit over here is 10 days. In 10 days, IBBI has to appoint a new IRP, has to propose IRP to the adjudicating authority. Yes. Now point number 14 talks about withdrawal of application. Adjudicating authority NCLT may allow withdrawal of application once you have filed the application for the CIRP. In such a case, adjudicating authority may allow withdrawal of the application of CIRP if application is made with the approval of 90% voting share of the committee of creditors. Let's say there are total number of 100 members in the committee of creditors. 90% of the voting share, if agree for the withdrawal of application of CIRP, in such a case, adjudicating authority may accept that application. Point number 15 talks about a creditor shall submit claim with proof on or before the last date mentioned in the public announcement. Once a public announcement is made by the IRP, then the general public, whoever is owing any money to the company, the corporate debtor, they have to file the application. They have to file the claim with the IRP, insolvency resolution professional. IRP shall verify the claims within the 7 days from the last date up to which the claim is to be received. So let's say a particular date is fixed, that is up to which the claims will be accepted. From that date, within 7 days, he has to verify all the claims, and within 2 days of the verification of the claim, he has to submit a report to the adjudicating authority. Now, constitution of committee of creditors. What would be the constitution of committee of creditors? Now, if corporate debtor has financial creditors, if corporate debtor has only financial creditors, then financial creditors will only be the members. If a corporate debtor has financial creditors, apart from that, operational creditors are also there. In such a case, also in committee of creditors, only financial creditors will be the members. Operational creditors can attend the meeting who is having outstanding debt of more than or equal to 10% or more. If a person is holding 10% or more of outstanding debt, in such a case he can attend the meeting but he cannot vote in such meeting. This is what this point talks about. In case corporate debtor does not have any kind of financial creditor, let's say there is no financial creditor into the company, in such a case 18 largest operational creditors shall be the member of committee of creditors. If there are less than 18 members, then all the members would be the part of your committee of creditors. There would be one representative of the workmen and one representative of the employees. So maximum there can be 20 members in case of committee of creditors if there is no financial creditors present in the company. Upon constitution, report to NCLT within 30 days. Once you have constituted the committee, you have to report to the NCLT within 30 days. First meeting is to be conducted within 7 days. IRP shall be part of the shall not be part of the committee of creditors. RP means related parties shall not be part of the committee of creditors. Equity shareholders are not entitled to attend the meeting. Equity shareholders whoever is holding any kind of debt with the company are not are not eligible to attend the meeting. All right. Point number 17 talks about conduct of other meeting of the committee of creditors. First meeting is to be conducted within the next 7 days. That we understood. The first meeting is to be conducted within next 7 days. Now, what is the voting percentage to pass a resolution? We are going to study. Now, voting by majority 50% or more as per the value of the debt owned generally. Generally, kya hoga? More than 50% if passes a resolution, then it is accepted. But this is what it is. We are going to discuss important voting percentages over here. Before this, let us finish the quorum part. Quorum, there should be minimum of 30% of total voting power should be present to have a valid quorum into the meeting. If no quorum is present, then the meeting is to be adjourned to the same time and place on the next day. Please be very careful with this. In section 173 with respect to meetings, we studied that in section 173 and 174 also. We studied that the meeting is to be adjourned to the next week at the same time and the same place. Here it is only next day, it is not the next week. So please be careful with this next day timeline. If no quorum is present into the extended meeting also, in the urgent meeting also there is no quorum present, then in such a case, whoever is present into the meeting, all those persons are to be considered as the valid quorum for that particular meeting. Now, resolution of 66% of the value of debt owns required for. मतलब 66% का resolution would be required if you are going to extend the CIRP timeline by 90 days. Resolution of COC for liquidation. If you are going to pass a resolution for liquidation in the committee of creditors meeting, then in such case 66% of the debt holders ka you have to have a consent. Appointment or replacement of IRP or approval of CIRP. All these processes, minimum 60% of voting share का approval आपको चाहिए होगा. 66.6% of value of debt required for voluntary liquidation. If they are voluntarily going to liquidate, then in such a case 66.6% का आपको approval चाहिए होगा. यहाँ पे it is only 66%, but whereas here it is 66.67%. So please be very careful with this particular timeline. All right. Okay. Now, notice of meeting is to be given at least 5 days before the date of meeting. Committee may reduce the 5-day timeline for a period which shall not be less than 24 hours. मतलब minimum 24 hours का तो आपको notice period serve करना ही पड़ेगा, even if the committee has agreed for a period lesser than 5 days. If authorized representative of the committee of creditors are present in the meeting, in such a case, the minimum notice period should be of 48 hours. Please be very careful with all these timelines. These are the most important ones, and MCQ will definitely be formed in your examination also. Point number 18 talks about a person shall not be eligible to submit a resolution plan. Now we are going to submit a resolution plan. Committee of creditors has come, they have agreed, they have decided, they have framed a resolution plan in consultation with the resolution professional. Now, who is not eligible to submit a resolution plan? Who is an undischarged insolvent? Who is a willful defaulter as per RBI? Who is disqualified under section 164? Who is prohibited by SEBI? who is punishable with jail for a period of 2 years or more as per 12th schedule, or 7 years or more in any other law, or who executed or enforced any guarantee in favor of creditors. Such persons are not entitled to submit a resolution plan. Now moving on to the submission of resolution plan. Now resolution plan shall specifically provide for payment of what? Whenever you are going to submit a resolution plan, the resolution plan shall mandatorily provide for cost of CIRP, such as salary of IRP, cost of paperwork, cost of business, cost of consultation. All these are to be mandatorily mentioned in the resolution plan. When resolution plan is not filed within 180 days of commencement date, then AA may pass order for liquidation. This is an important timeline. Please be careful about this. Now, initiation of liquidation. Before this, let me see. Yes, let us discuss this first. Formulation and submission of resolution plan. How the process will start. Now, there is a rejection of resolution plan. There is approval of resolution plan. We have submitted the resolution plan within 180 days. The timeline we discussed earlier, right? Within 80 days, 180 days you submitted the resolution plan, the adjudicating authority may either accept it or reject it. If they have accepted the resolution plan, in such a case, the moratorium period, the calm period during which any legal suit or any kind of legal action cannot be undertaken, all those will be kept in abeyance. That period will cease, and there will be implementation of resolution plan. But in such a case, there is a rejection of resolution plan. In such a case, the liquidation process होगा, appointment of liquidator होगा, formation of liquidation trust होगा, consolidation and valuation of claim होगा, और distribution of asset होके company बंद हो जाएगी. This is what happens when resolution plan is not accepted. Once it is accepted, then the company will carry on its business, but the structuring would be done as per the resolution plan. Now moving on to this initiation of liquidation by the adjudicating authority. Adjudicating authority can initiate the liquidation if resolution plan is not submitted within 180 days plus 90 days extension period if any granted to the company. May reject the resolution plan for non-compliance of the requirement. NCLT may order liquidation if COC passes resolution of 66% to liquidate and intimate it to the NCLT. So NCLT either may suo moto initiate the liquidation process, or may upon a resolution passed by the committee of creditors by 66% का resolution is required, then in such a case also liquidation can be ordered by the NCLT, or there is a contravention of the provisions of this particular act. In such a case also a resolution liquidation can also initiate. Normally जो RP होता है वो भी appoint हो जाए liquidator in case of your liquidation. The liquidator is normally the resolution professional, but in case you are going to change the resolution professional, then the committee of creditors has to pass a resolution into the meeting. Consolidation of claim is to be made within 30 days from the commencement of the liquidation proceedings. Correction is allowed within 14 days from the submission of claim. Once you have submitted the claim, you can make the correction within the next 14 days. Confirmation is to be made within 7 days from the acceptance or rejection of the claim. Creditor may appeal to the adjudicating authority against a decision of liquidator, accepting or rejecting the claim within 14 days of receipt of the such decision. Now, liability of the previous offences. Let's say liquidation process has been initiated. What would be the liability of the promoter and the director? Corporate debtor will be prosecuted and liable for offences prior to commencement of CIRP after approval of resolution plan by the NCLT. If NCLT has approved the resolution plan, then the corporate debtor would be responsible for any kind of offences that has been commenced, that has been undertaken prior to the commencement of CIRP. If CIRP leads to change in management, if due to CIRP there is a change in management, then the management or promoter prior to the CIRP shall be liable. If they have no knowledge with respect to any kind of default, then they shall not be liable. No action can be taken against the property of corporate debtor if such a property is involved in CIRP and approved by NCLT, which results in change in control of such property. If there is a change in control of such property, in such a case, there cannot be any action taken against such property. Consequences of non-submission of resolution plan: NCLT may order for liquidation. Failure to conduct the events, the table is given on the next page. We will come on to the table later on. Now, the last point is fast-track CIRP for small corporate companies. In the old syllabus, there were a lot of content given with respect to fast-track corporate insolvency resolution professional process and pre-packaged insolvency resolution process. But in the SPOM, all those provisions has been removed. Only this one-liner provision has been kept. For whom a fast-track CIRP is applicable? It is applicable for a small corporate person, where an enterprise is a small company definition as per the Companies Act, or a startup as recognized by the DPIIT, or a listed company with total asset not exceeding rupees 1 crore. Unlisted companies के लिए if the total assets are not exceeding ₹1 crore, in such a case those companies can also go ahead with fast track CIRP process. This was all about your IBC revision. The last point is with respect to your, if there is a delay, if there is a failure to conduct the events, then what is going to happen? Public announcement is not made by T plus third day. Public announcement is to be made by the IRP within the next 3 days from the date of his appointment. If he has not made such public announcement, then what is to be done? A timeline for filing of CIRP. Sorry, timeline for filing of CIRP for the first time. Just a second. Yes, timeline for filing of CIRP 7. So the form number 7 you have to file up to what period? Now the date specified in column 2 plus 3 days, that means whatever date is mentioned over here, you appointed as IRP, and then the next 3 days you have to file the public announcement. But if you have not done that, then CIRP 7, form number CIRP 7 is to be filed within next 3 days. Timeline for subsequent filing of CIRP. The first CIRP form is CIRP form 7 will be filed within the next 3 days from the date of public announcement if not made. And the subsequent is to be filed within the X plus 38 days. So what does the meaning of X? X ka meaning this timeline. This T stands for X. So whatever is the timeline for making the public announcement from dated within the next 30 days, within next 60 days, within the next 90 days. So matlab every subsequent 30 days you have to file form CIRP 7 until and unless this requirement is not fulfilled. Point 2 talks about appointment of IRP is not made by T plus 38 days. If you have not appointed resolution professional in the T plus 38 day, then you have to file form CIRP within the next 3 days plus 3 days and every subsequent 30 days from the date up to which the RP was to be appointed. So I believe that all these provisions, these 3 and 4 and 5th, these 3 also you can also understand with respect to these 2 examples. That's what about the revision of IBC. I hope you like this video. If you like the video, please share with all the friends and please do comment in the comment section because that motivates a lot to come up with the next chapter. I hope you enjoyed the video. Please like, share and subscribe to the account, and thanks a lot for watching. Thank you so much.